right. I think maybe we're ready. So welcome. Hello, everyone. Thank you for joining us for today's webinar. My name is Ann Russo. I am the Executive Director at the Building Officials Association of Florida. Today, we are presenting the 2022 legislative session web wrap-up. Your panel of presenters includes BOAF Legislative Committee Chair Ron Leiseca, committee members Doug Harvey and George Wiggins, and we are pleased to welcome the Florida Fire Marshals and Inspectors Association's second Vice President, Tommy Demopoulos. We are not attorneys, and all comments are just that. They're just comments and our opinions. The information in this webinar is not a substitute for reviewing the legislative changes with your city or county attorney. And just a little housekeeping before we get started. This is a webinar. You can hear us, but we cannot hear you. If you have any questions during the presentation, please type them into the question box in your Zoom panel. We should have time for questions at the end of the session. And the session is being recorded, and we hope to have it available on the website later this week. So without further ado, we will turn the time over to our chair, Ron Leiseca.
Well, good afternoon. And as Ann mentioned, we have a segment of volunteers here who are helping us with regards to making the presentation on these different bills. And you may have some questions, you may not. Some may be more complicated than others, so please type them in. We're going to do a round robin with regards to each of our members who have taken on a couple of bills to give you a better comprehension of them, probably within 2 to 5 minutes of each, and then we'll hold the time for additional questions. Doug, Senate Bill 352, the modifications to the limitations on the notice of commencement.
Thank you, Ron. Thank you all for being here. Pleasure to be with you today. We hope you'll learn something from us. So what this does, it may seem very minor, but there are other pieces in here that we also need to remember. And this revises the threshold for direct contracts dealing with change outs for existing heating or air conditioning systems. And the key to this is to remember that it deals with the direct contract for repair or replacement of existing. So if you're dealing with new equipment, this most likely would not apply to you. I think everyone knows the typical threshold for a notice of commencement is $2,500. And for air conditioning systems for the repair or replacement of existing, it has been $7,500. This bill, this legislation changes that to $15,000. Just one of the real important point to keep in mind on this is that within that statutory wording in Florida Statute 713, it is not required to have a recorded notice of commencement prior to the issuance of a building permit. So just FYI. And I think that wraps that one up. Ron, back to you.
Thank you. And on House Bill 375 that establishes the Structural Engineering Recognition Program, George, you have a few choice wisdoms to share with us.
Thank you. Good afternoon, everybody. For all of those listening in, it's my pleasure to give some information on some of these bills and assist with this webinar. House Bill 373, whose sponsor was Representative Jim Mooney, who represents Monroe County and part of Miami-Dade, presented this bill, and it was passed and enrolled. The bill does create, through the engineering board, a structural engineering recognition program, and I emphasize program. It requires that this board provide this to licensed professional engineer who has successfully passed a specified examination. And that examination has to do with, of course, structural engineering to shore up the credentials of a PE, of a professional engineer, to provide some additional training that's related to structural engineering, because as you all know, the designation of PE professional engineer includes all of the areas of expertise related to engineering. It could be a chemical engineer, an industrial engineer, electrical engineer, And we as building officials have for years tried to provide some assurance when we're reviewing plans that are signed and sealed by a PE engineer that they in fact have some credentials or the ability to prepare plans and seal plans for the structural aspects of a building. The bill also creates this examination, which the specific wording is as follows. The board must recognize any licensed professional engineer who has successfully passed the National Council of Examiners for Engineering and Surveying or any other examination approved by the board. There is no fee for getting this designation, but the bill does allow the professional engineer to add this to their credentials, and they can indicate that in their preparation of plans that they have had this additional training. The effective date of this bill, should it be passed, is July 1st, 2022. So that's basically everything the bill covers. One further comment I might mention that I'm sure might be raised by many of y'all, that it doesn't resolve the concern that we've seen having non-qualified professional engineers preparing and sealing structural plans for buildings, which has been an issue for building officials for ages. But for those that go through this examination process, it might provide some additional assurance of expertise. With that, I'll turn it back to Ron.
Thank you, George. And you are correct that the designation doesn't recognize that you have actually passed the national boards for the specialty of structural engineers. The governor did sign the bill, so it is law effective July the 1st. And Celeste, you have something for us? Quick little question.
So if you all would indicate true or false, and then we'll take a look at how you all responded in a moment. Well, if you want to close that poll out for us, please.
Well, it's pretty good. At least everybody recognizes it's a recognition and not a specialty license. It's pretty good. All right. House Bill 423 is an act that's relating to building regulation, the private provider, issuance of certificates of completion and occupancies, limitation on processing of application for permits, and civil action with regards to retention of building permit funds in excess of the carryover in accounts. It has a lot. It's 20 pages long. And basically the main aspects of it is the private provider designation has the same meaning under Florida statute 553.791 subsection 1. It allows internship programs under the private provider to be fully recognized while the intern operates under direct supervision of a certified building official. And I'm reading my notes because it's a long one. Allows the transfer of internship programs between different jurisdictions, private providers, and firms of private providers. The board may not place special conditions on provisional certificates issued on employment by either a municipality, county, or other local governmental agency, which means that private providers' employment will count towards their internship if they are registered in an internship program. The private provider has the right private owners have the right to obtain a permit to demolish his or her single-family residence located in flood areas and is not subject to additional land development regulations or public hearings, and new permits for replacement of residence may not subject it to additional requirements in comparison to a similar vacant parcel, and it's subject to those limitations. Owner and private provider access to permitting, inspection records, and reports, including electronic access, is subject to software protection. Just an aside on this one, the private provider and the owner have the right to access the records. However, as part of the electronic access, that depends on the security of your current software, whether it will allow it and just allow them to search those records and not search certain restricted records or those that are protected by law. Requirements that a certificate of completion or certificate of occupancy be deemed issued within 2 business days for single and 2-family residential construction and 10 business days for other occupancies if all documentation, required approvals, and payment of all outstanding fees is submitted. So this is deemed to be automatic if you take no action. As I said, it's a long bill. It also has detailed time limits for review and request for additional information on permit processing, leading to a decision to either deny for specific reasons, requiring the refund of permit fees, or automatic issuance of such permits as deemed to comply within the requirements. To make a long process short, basically you have to define what is required, so therefore you don't go into a timeout situation. And we can have some questions on that to expand on that. And I know that both Doug and George have comments with regards to that. The one last item that was added was with regards to civil action being permitted by permit purchasers and allowance for joining of interested parties to sue local governments for excessive carryover of permit fees in designated accounts for future years in excess of documented and proper amounts. In English, it allows a civil action which was not allowed before to force the local jurisdictions not to keep too much money in their accounts that they cannot justify and force a refund or lower fees as far as future permits. And that bill does take effect July the 1st. And we do not have any strong reasons to believe it will be, shall we say, not signed by the governor. In other words, it would not vetoed, let's put it that way. So moving right along, Tommy, you get a simple one. No, I'm sorry. I go back to Doug. Tommy, stand by. Senate Bill 518, maintenance and tree removal. Doug, you can have fun explaining that one.
Thank you, Ron. And this is kind of an interesting bill. And those of you that have a separate environmental resources, a landscaping division, maybe an on-staff arborist, something of that nature that you have to deal with, you're going to want to pay attention to this one. And I'll just read you what the beginning of it says: an act relating to private property rights to prune, trim, and remove trees. And that kind of sums it up. There is a stipulation in here, and you have to go to the definitions. When you get into the definitions and you look at what they call documentation, this is really the key to putting this bill in place and being able to explain it to people, is you want to refer to this, and documentation means an on-site assessment performed in accordance with the tree risk assessment procedures outlined in, and they give you an actual document, Best Management Practices Tree Risk Assessment, 2nd edition, 2017, by an arborist certified by the International Society of Arboriculture, ISA, or a Florida licensed landscape architect, and signed by the certified arborist or licensed landscape architect. What it boils down to is that if you have a tree that needs to be trimmed, pruned, or removed, and that tree has been deemed to be, if it is deemed to pose an unacceptable risk, then the municipality cannot prevent the trimming, pruning, or up to and including the removal of that tree. You know, in many cases, there are requirements for mitigation. This prohibits mitigation. You know, that some places have the inch for inch, or you have to put in 3 palm trees to equal 1 other type of a tree, or whatever the case may be. This actually prohibits that mitigation from taking place. So if you're dealing with that as part of your land development regulations or as part of your local landscaping code, you're going to want to pay attention to Senate Bill 518. And again, as Ron stated, we're having a governor who is very keen on deregulation. We don't have a lot of reason to believe at this moment that this would be vetoed. It has been enrolled by the House and Senate and sent to the governor, but to the best of my knowledge, it has not been signed as of yet. Thank you, Ron.
Yeah, Doug, as of yesterday, it has not. And also, it does only cover residential property, which is single-family detached buildings. So luckily, it doesn't give the commercial property owners the same flexibility, can we call it? And we have a poll question on 518. Okay, and Celeste is, okay, everybody is doing well today. So let's close this out and move right along. And Tommy, you have the one which is House Bill 615, which is an act relating to human trafficking. And if you could kind of, you know, it sounds like what are we doing in here? And if you can give us a little bit of enlightenment, that would be great.
Yeah, good afternoon. First, on behalf of FFMIA, we truly appreciate the opportunity to be part of this and welcome the input and thank you again. But House Bill 615 states that training shall be developed for fire safety inspectors in the recognition and reporting of human trafficking. And then it also allows that training to be to count towards your CEUs for fire safety inspector. This is not anything that is mandatory, but this is a good thing because the fire safety inspector is in a position to potentially recognize this human trafficking and they would have the proper steps to report this human trafficking. And at the moment, we do not see any reason why this would be vetoed or not signed. And this does take effect July 1st, 2020. Thank you, Ron.
It's more of a thing about having another set of eyes out there looking around and contacting the proper agencies if they see something.
Correct.
All right, Tommy, you got the next one also, which is Senate Bill 838, which is an act relating to fire investigators.
I do. So 838 changes some of the definition of firefighter, and it includes it says full-time Florida certified fire investigator. And basically it allows that Florida certified fire investigator to be covered under some of the cancer treatments. Before it was just the firefighter who goes in and extinguishes the fire, not including the public sector investigator that comes after to try to determine what the cause and origin of that fire was. So this kind of includes that fire investigator at this moment.
Okay. And that one also is scheduled to take effect July the 1st, once it's signed by the governor, which it has not yet been signed. It's one of those that is still in transit from the legislature over to the governor's mansion. George, you have Senate Bill 856, which is an act amending section 351.0065 Florida statutes authorizing private providers with the ability to inspect on-site sewage treatment and disposal systems subject to qualifying conditions. Boy, is that a long title. I love the legislature when they come up with some of these. It's all yours, George.
Yes, that Senate bill, again, 856, was sponsored by Jason Brodeur from Volusia and representing Volusia and Seminole counties. It is an act that authorizes private providers expanding their role and responsibility on construction sites, the ability to inspect on-site sewage treatment and disposal systems, subject to some qualifying conditions.
Mm-hmm.
What those conditions consist of are and I'll go through the list. A private provider of or an authorized representative of a private provider may perform on-site sewage treatment and disposal system inspections if they are one of four entities. Number one, an environmental health professional certified under Florida statute 381.0101. Or number two, a master septic tank contractor, professional certified, let me back up, a septic tank contractor registered under Part 3 of Chapter 489 Florida statutes. Or number three, professional engineer licensed under Chapter 471 and having passed all parts of the on-site sewage treatment and disposal system accelerated certification training. Or number four, an individual working under the supervision of a licensed professional engineer and having passed all parts of the on-site sewage treatment and disposal system accelerated certification training program. It authorizes the Department of Environmental Protection to audit the performance of up to 25% of the inspections each year. It requires acknowledgement form specified in law be executed and submitted to the department. And it requires the department to submit a report to the President of the Senate and the Speaker of the House of Representatives, reviewing the use of private providers by October 1st, 2023, for reviewing this system of inspections as authorized by this subsection. The report must include at a minimum the number of such inspections performed by private providers. Again, this is introducing a new legal responsibility allowance for private providers that they had not had in place before. I would think this would be most useful for the home building industry, where they're using the private provider statute to inspect homes of large subdivisions and maybe in semi-rural or rural areas where septic tanks are allowed for use in the state of Florida. This would become effective July 1st, 2020, should it be signed into law by our governor. And also there's one more bullet point, is that the department will have to adopt rules to initiate rulemaking by August 1st, 2020 this year. So with that, I'll turn it back over to Ron.
Yeah, it's 2022, George. There was a typo.
Oh,
Which-
was it 2020?
Yeah,
Okay,
it was a
thank you.
small
I
typo.
wondered that it was awfully soon.
It happens every so often, but it's interesting that they allow them to do that, but at the same time, they also have to have additional training and certification. So the next one, Tommy, is Senate Bill 1140, which is with regards to the alarm systems.
So there's a few things with 1140. First of which it doesn't really affect us, but it allows a trade-off for NICET level 2 or higher technicians to only have 2 hours of CEUs for every 2 years instead of a 6. So there's a little bit of trade-off for the education in regards to the CEU requirement. It also modifies the definition of low voltage alarm system project to include CCTV. And then lastly, a bigger item is it provides for a simplified permitting process for fire alarm systems. Basically, if you're altering an existing fire alarm system with 20 or less devices, it's more or less an over-the-counter permit. The inspector would go out, do the inspection, the plans are on site, and it provides a little bit of customer service and a little bit of expediting of that plan review process for those existing fire alarm systems, 20 devices or less, or the replacement or installation of a fire communicator in an existing system. This also takes effect July 1st, 2022.
Okay. That's interesting. And we have a little poll question here. Okay, so I guess everybody has given their 2 cents. And that is correct. False is the correct answer, that it does recognize it as a low voltage system. All righty. Tommy, you have the next one also, Senate Bill 1190, which is an act relating to two-way radio communication enhancement systems. And I know that this has kind of been bounced around for the last couple of years. And I hope that this is kind of the last final tweaking to get this thing to become reality.
Yes, so this is one of the bigger bills in the fire service. I know it has come a long way from when it was first submitted. It had a lot of different language and some other requirements that would be detrimental to some of the firefighter safety. Some negotiations or some revisions of those requirements were had. And basically it adds and removes the word high rise in multiple places to provide some clarity. Before, the way it was existingly read or written, it led some confusion to some of the HJs on, well, is this section related to high rise or apartment building? So it adds the wording high rise to kind of clean up that confusion, if you will. And the bigger thing is it exempts apartment buildings 75 feet or less in height that have less than 150 dwelling units and is constructed using wood frame construction, provided that the dwelling unit discharges to an exterior or to a corridor that leads directly to an exit. If it complies with those requirements, they do not have to install a radio enhancement system. So it's, the way it was written prior was confusing, but it didn't have these restrictions. And like I said, the way it was originally submitted, this is a long way from it. It is not perfect by any means. I do see this passing. I don't think there will be any hesitation from the governor, as we've kind of been talking about in the past. And this does take effect July 1st, 2022.
Okay. Yeah, I think it does clarify a lot of things that before were kind of a little mushy, shall we say. And I think that nobody, well, I shouldn't say nobody, because there's always somebody that has a little bit of a peeve with some of these things that are required. But I think right now, there is really no major basis to complain about the bill from that standpoint. Last, I kind of close this act with regards to House Bill 7053, which is an act relating to the statewide flooding and sea level rise resilience and establishing the Office of Statewide Office, or the Statewide Office of Resilience. And the interesting part is the bill covers a couple of different things. One is the requirement that the Florida Department of Transportation create a resilience plan. So therefore, they're going to talk about the roadways and they're going to study which ones flood too much, what remediation efforts need to be done. Part of it would be with regards to evacuation from certain areas into lower, let's say, areas that are not as exposed in case of a storm is coming in. They also create the statewide Office of Resilience with a chief resilience officer, which all would be under the office of the governor. And the chief resilience officer would be hired and would start making reports that some of them are due before the end of the year. Incidentally, the bill does not take effect until July the 1st. So I hate to be the applicant that has to become the chief resilience officer, because he's going to have his hands full, because it is subject to approval by the Senate. And of course, hopefully that won't take too long, but the poor person has a lot to do within about 4 months. It does create a requirement for a statewide inventory of basin level flooding assignments as a report and to address such conditions, and also creation of a grant program. The grant program is interesting in one aspect. We always know that grants are subject to budgets, but this one creates not only a methodology to apply for the grant, but if you have a project that's going to take more than 1 year, let's say it's a 2 or 3 year project, which we know that that's not unusual, it does give them priority to be funded before anything else. So therefore, if you have a 2-year project, let's say it's worth $75 million and you pull $25 million the first year, second year, maybe $50 million, you have priority once you are approved to be funded for the second part. And it does set a minimum funding requirement of $100 million. So maybe the legislature is trying to do something about this for a change. Last, it also requires the development of a statewide database identifying and documenting those assets that are vulnerable to current and future flooding. And they do talk, and Doug, I think you kind of got into this a little bit about, they are talking about 100 and 500 year levels with regards to some of the flooding requirements, as far as creating the database and using those as particular planning models, I guess, that you have to model it for a 100-year flood and for a 500-year flood. If I remember correctly, after having read the bill like 3 times and been confused twice. And Doug, you want to say something? Yes.
You are correct, Ron. We're having a lot of discussion about the 100-year and the 500-year. We're seeing the 500-year come into more of the firms as the flood zones get moved around. Mm-hmm. And then for anyone who's dealing with coastal here in the state of Florida, where you're dealing with the coastal construction control line, mm-hmm. You're also dealing with DEP, and you have to remember that that is actually an erosion model, mm-hmm. which is based on the on a completely different modeling program than what the flooding is based on. Thanks, Ron.
Correct. And also, I think that that's going to lead to some thinking with regards to what is the coastal control line, what is the more exposed areas. For example, I live in a barrier island, and believe it or not, I am not considered a hurricane velocity hurricane zone. And I keep looking and I go like, well, across the river, that is considered a flood thing, and yet this is not, and that's considered a hazard, and I'm not. This is not the proper thinking. So I think the map guys went out to lunch and had a couple of martinis and forgot about us to designate it properly. The other thing that it does do, if I remember correctly, with this vulnerability database, is that it is going to cast more emphasis with regards to the essential services, be they emergency operations centers, fire stations, hospitals, police stations that serve dual purposes, of course, and also our shelters, which are, a lot of them, of course, are schools. So I think that that's going to create a little bit of an issue, especially with the 100 and 500, where all of a sudden we're going to see a certain spike in minimum elevation, shall we say, as far as being requirements in order to get the proper funding with regards to the grants that will be available, hopefully, from that standpoint. And incidentally, this is not only effective July the 1st, but it was signed by the governor, so this is a given. And for those of you that can see some of these little issues, as Doug mentioned, creeping up, you're going to have to get into it, because among the many little things in this bill is a requirement that the local agencies, municipalities, governments have to give reports to this Office of Resilience, and some of them are due at the end of this year and will be done on an annual basis. And of course, if you want a grant, you got to document it. So therefore, you got to get with the program, so to speak. And with that, if there's any comments from our panelists before I open it for, oh, I'm sorry, we do have a poll question. I think I gave away the answer. Okay, I see that we have one of the answers is to us and false. Yes, it is to us. It is true.
I'm sorry about that.
Well, we have to have some fun and see if these guys actually do read the written word. And there's the old joke about we can make jokes and we can laugh about it, but some of the governmental agencies, when they make a joke, they call it either a state or a federal statute. And hopefully they don't do any of those within our legislative bills. Any comments from any of the panelists with regards to this or any other bill that they want to add one or two words before we open it to questions? That's it. Okay.
All right.
Celeste, go for it.
Thank you, Ron, Doug, George, and Tommy. We're going to go ahead and take some questions now. And so just a reminder to the participants, please be sure to type your questions in the question box in the control panel, and it will help me if you reference the bill number in there with that. So Tommy, I think we're going to start with you on that Senate Bill 838. Will the new definition be included with FRS benefits, or does it only pertain to cancer benefits?
The current moment, the bill is simply revising statute 112.1816, which is titled Firefighters Cancer Diagnosis. And there is a list of 21 different cancers that are covered under this bill. But the wording here specifically revises the definition here only for the term firefighter to include that full-time Florida certified fire investigator.
All right. On Senate Bill 352, Doug, you covered that on that notice of commencement. Do we expect the governor to approve or veto that? Does the panel have any predictions on that one or insight?
I don't at this time. I don't know if anyone else does. I wouldn't really expect it to be vetoed because that is more of a business friendly type of a move.
As far as the comments I have gotten from a couple of the local AHJs I've had conversations with, nobody is having any real issues with it. In fact, one of the comments I received was the fact that they wish that the trigger amount for permits be raised. And there's been a discussion on that, whether, we need to raise it to $5,000 or whatever. So that's one of the other kind of feedback with regards to that particular bill that we've received so far. But no, I don't expect the governor to do anything other than sign the bill when he gets it on his desk.
All right. Looking at House Bill 423, is the 10-day limit in regards to the application for a certificate of occupancy to be issued still in the bill? When they looked at the final analysis dated March 11th, it was only mentioned on the first page. The specifics on time limits for a certificate of occupancy to be issued with a 10-day limit doesn't appear anywhere else in the analysis. And do we know if 423 has been signed?
423 has not been signed. There is no indication it will be vetoed. As far as the 10-day for other than single or two-family residences, that is applicable. What the bill says basically is if you receive the documentation and it is complete and it meets all the other little requirements, which include that you have to have all your payments, you have to have all your other approvals, and the other approvals, remember, can be outside of the building department or under the control of the building department. So for example, if you have a flood sign off, if you have a impact sign off or such that is also required as part of the completion, that will hold up your CO. But if all of those are there, then the trigger is the 10-day for other than single and two-family residences. And then after that, I hate to use the word deemed to comply, but it triggers the deemed to comply. And therefore you have 10 days to then issue the paper certificate, so to speak. So that is the trigger, which means that you have to make sure that when that request for the certificate of completion or the certificate of occupancy is received, that you also check and make sure that they have all the other things that is in your folder for that particular permit and that particular folio, that it's there. And if it's required and it's not there, you can't process it, and that's a legal basis. And I'm not an attorney, So please check with your legal beagle. I have friends that I call them legal beagles and they laugh about it, but make sure that you check with them and make sure that you documented that, hey, the reason I was not able to sign this off is you were missing this particular one. Maybe it's a fire signed off. And if it's not there, I can't issue it. And that's a legal basis for it. But if it's all there, that's the trigger. 2 days, single, 2 family, 10 days for other.
All right, we're going to stay on 423 for another minute. Our plan review times, reviews more than 3 times, et cetera, does that apply to private providers as well, or only to municipalities?
Okay, Doug, do you want to pipe in on this one? Doug's laughing.
Sorry, I had to find the unmute button.
Okay.
Well, I believe that the wording is in regard to plan review. And I don't think, which bill was that again? That was in 423.
It's the one that we call the 3 times and you're out approach to it. But Doug, give your opinion, because I have mine, and I think it's time to get others to get involved in this wonderful little bill that they've shoved down our way.
I think I found it in the bill. It does say to local government, application to local government.
Yes,
And
that's the way I read it.
Line 321 of the bill.
Yep.
In several places in here, it does specifically say local government.
Yes.
In 321, 348, 360. So I would have to say that, no, it does not apply to private provider. And I think that there's probably a valid reason for that, in that private provider is actually a business. And if a private provider is not working with their customer, that customer is either going to go back to the local government or they're going to find another firm to deal with. That's my thought.
All right. Still on 423. Was there anything about provisional licensing applying to private provider realm, or is that still only an option or government inspectors?
You're talking on internship, I'm assuming. And as far as internship, there is a requirement that has about applying for provisional as far as the inspector. And it would be the same whether you're going through the private provider internship program or you're going through the governmental entity private provider program.
All right. I think this one is back to you, Doug. Still talking about the private provider. So what if the city hires a private provider building official?
I believe that is actually addressed in 468. And there were actually 2 questions that had come up that were related to 468. And let me get back to that section. I apologize, I had gotten off of the section to go over to another one. 468.604 actually states it's the responsibility of the building code administrator. That wasn't the one I was looking for. Where it does talk about under the definition of building code administrator or building official means any of those employees of a municipal or county government or any person contracted with building construction regulation responsibilities who are charged with the responsibility for direct regulatory administration. So they have expanded the building official position to include and you can't really call it private provider because it's not private provider, it's municipal service. Private provider is very specific under 553.791. And that is a contract between either a building official or a firm and the contractor or the owner. Okay, under the actual building official, building code administrator position, the board refers to that as the person who is acting as the governmental entity's representative, not under contract with the owner or contractor. So I don't know if that muddies the waters or helps clear it up, but there's long been a discussion about who is called what, and that term private provider was actually being used before we actually had the definition for private provider. And we now have that definition. So you have to separate municipal service and private provider. Thank you.
All right, we're going to switch over to Senate Bill 1140 for a minute. So many fire alarm permits are alterations on existing fire alarm systems with less than 20 devices in the scope of work. Seems that this legislation will cause more issues with an as-built inspection process for existing systems. Also, it doesn't take much to initiate engineering requirements with a $5,000 threshold. How will this affect engineering review? Can you comment on the 61G engineering process in your fire department?
Tommy, do you want to handle that?
There were a lot of parts to that, and I will try my best to remember them all. So remember, this is for an existing system only, which most likely had engineering documents when it was originally installed and approved. Adding that communicator or moving a few devices shouldn't, but can. I get the point of it doesn't take much to bring things up to 5,000 or over 5,000. So that's possible. And just remember, the inspector going and doing the inspection has the ability and can deny in the field if they see something wrong. So if you have concerns about battery calculations, or you have concerns about potentially a cost and needing an engineer to get involved, that person in the field has the authority to deny it until such complaints or until such items are rectified. It's more of a expeditious process to try to get the plan review portion through. So I don't know if that answered some of that.
Still on 1140, said for a cellular communicator, I currently require the contractors to submit a simple plan and to identify if the communicator will have its own power source with battery backup or be powered through the FACP. If powered through the FACP, I require a new battery calculation for the FACP to ensure that the existing batteries will be sufficient to handle the additional load of the communicator. Will this bill no longer allow me to require that in the permit process pre-installation?
In the permit process pre-installation, you would not be seeing a set of plans. So I guess the answer to that would be no. But in the field and in the inspection process prior to approval, yes, you can require that and have an opportunity to look at that.
All right. Tommy, I think this one is still yours. Senate Bill 516, but I'm not sure if that's the right number. Will the training for fire inspectors to recognize human trafficking count for required CEUs?
Okay, 615.
Okay, 650. Okay.
615, yes, it actually states in there that it will count or can count towards CEUs. And we actually had a phone call with the Florida State Fire College earlier this week to see what that will look like, what the instructor qualifications, is there already an approved curriculum out there? So there are discussions behind the scene currently on what that will look like. But short answer is yes, it will count towards CEUs.
All right. On Senate Bill 518, I just looked up the title of the document for the arborist and got a whole bunch. Do we know which one? And is it only from the tree health point of view? Is anyone familiar with it? Does it cross-reference any of the challenges that occurs with storm damage or wildfires?
No, the bill is actually very straightforward, and it does give the documentation, says that it must be from that book, Best Management Practices Tree Risk Assessment, 2nd edition, 2017. And then it's got to be done by an arborist certified by the ISA or a Florida licensed landscape architect. And whoever does it must sign the report. As Ron stated, it is limited to residential property, and the way that the last part of the bill reads, it says removal of a tree on a residential property if the property owner possesses documentation from an arborist certified by the ISA or a Florida licensed landscape architect that the tree poses an unacceptable risk to persons or property. A tree poses an unacceptable risk if removal is the only means of practically mitigating its risk below moderate, as determined by the tree risk assessment procedures outlined in, and then it gives the title of the book again. So I believe it's very specific.
And you have to remember, this just is talking about maintenance and tree removal in normal circumstances. I don't think that the other factors that come in after the storm, et cetera, would trigger it. What this is trying to do, whether we like it or not, is to override a lot of local ordinances that are making it very difficult, in the opinion of some people, to prune a tree or remove a tree where you have to have all those reports, special permits, inspections, et cetera. And it's just saying, why? No, we're not going to do it that way. And I don't think that it's going to be vetoed by the governor. I think this is going to fly straight through as part of the Make Things Simpler program.
All right, back to 1140. Does it limit the fee for expedited permits for fire alarms? And I'm going to combine two questions here. Has it been signed yet? As of yesterday, it had not. So,
Correct.
Yeah, I'm pretty sure I looked this morning, it was not either. And about the fees, no, there is no mention at all about any reduction in fees or eliminates fee collection.
Yeah, I think, Tommy, the only thing it does address is it simplifies the permitting if you're doing replacements within that scope, but it doesn't mention anything with regards to permit processing as far or fees.
Correct, no mention to fees.
all right. On 423,
Oh, God.
we've got a couple of questions. Are there any efforts from BOAF to request that the governor veto it, or, you know, that we are not supporting this?
We have not, as the board has not approved any letter of opposition with regards to this particular bill for several reasons. We have mixed feelings about it. The bill that we originally had, which did not have all that other good stuff in it, was acceptable, but unfortunately the House leadership added a lot of the stuff that we are having heartburn about. And based upon the politics as is, we do not believe that the governor will veto it. I know I've had a couple of conversations with people on more local level, and my answer to them is cite specifics that you have heartburn about, that you feel is outlandish or whatever you want to term it, but give specifics and send it to the governor. The governor has not received the bill, so therefore there is time. But the BOAF as of today has not done anything with regards to it. It may be on the agenda for a upcoming board meeting. And I'll dump this back to you.
All right. Moving back to 518, does the arborist have to visibly inspect the tree?
It does say on some.
And I'm gonna give you two questions here. Does the arborist have to inspect the tree? And is there any recommendation on how to respond to HOAs and similar governing bodies that want to control tree removals?
Doug, you take the first one. I'll take the second part about the HOAs.
Oh, you would. You're taking the easy part.
Because I sit on a board with an HOA. I can tell you that.
I thought this was going to be one of the easy bills. I got to be honest. What the arborist has to do is the arborist has to comply with the rules and the items that are set out within that book. I believe it would be just like with an engineer. If an engineer can look at a video or can look at a picture and make a determination, then they may be able to do that, but they have to comply with what the book requires them to do. And Ron, I'll turn it over to you for the second part.
Okay, as far as the HOA, having a couple of years ago, we had a situation here with regards to one of our local homeowners that posed a question, and we went to our legal consultant about that, because we have a CCRE, which is covenants and restrictions that are filed as part of the documentation for the HOA. Those, if you have an HOA that has that as part of a CCRE, it will control, and the requirements that the particular HOA have still have to be met. Now, personal, our HOA CCRE requires our architectural review board to give an opinion, or excuse me, to have the homeowners submit any tree removals to it, subject to certain limitations, including trees that may be too close to the house, may be dead and would harm the property. Therefore, it's a given. Therefore, we give an automatic approval. Trimming is not part of the normal review. But if somebody says, I don't like that tree and it's 15 feet outside my house and I don't want to have it anymore, but it doesn't meet all the criteria, basically they don't have a given, even if the arborist says, oh yeah, it's an unwanted tree or whatever the moderate thing is. So it's more up to what the documentation creating the HOA legally would apply, yes or no. And that's a legal opinion that you have to go get to your legal consultant to give you that admonition, or say, yeah, you still control it.
All
That's
right.
what you can do.
All right. Thank you, gentlemen. So looking at Senate Bill 352, is there language to strike the words certified copy as a requirement to submit the recorded NOC to the permitting office?
That's a good question.
There has not been any change on that I am aware of. It's been talked about for quite a while that the statute is behind the actual process. Most of the records from the clerks of courts are actually found online now. They are readily available. And I know here in my office, we take a look at the recorded copies online, but because of the statutory wording, we are still required to have a copy of the recorded NOC in our permit file. So we do get a copy of the recorded NOC, whether it is delivered by the owner, the contractor, or we download it from the clerk of courts. However it gets here, we do our best to comply with the statutory requirement.
And I just looked at the bill and know there is no modification with regards to that. So that backs up what Doug just mentioned.
All right, a couple of questions.
Can I make a comment on that?
Sure, Doug.
This is
George.
George. We created a process working with an independent subcontractor with the county whereby documents requiring a recorded notice of commencement can be done in our office. So, and that process is available to other municipalities and counties throughout the state, that to ensure that we receive a certified copy of the recorded notice of commencement, mainly because we're recording it for them for a small fee, and has provided a great service. And we even provide the service to individuals that are not located within the city limits, since it directly communicates with the clerk of the court and for recording documents.
Thank you, George.
All right, on House Bill 753, I've got two questions here I'm going to throw at you. How will the state determine what assets are vulnerable to flooding? And 753 provides limits. Does 753 provide limits other than the residential stated of buildings requiring TWRCES, for example, 4,000 square foot single story business occupancy? So what assets are vulnerable? And then does it provide limits?
You're talking about 7053, and it does require that it have a report, and the new chief resilience officer is going to have all this information together and is required to submit a report to the governor, the president of the Senate, and the speaker of the House by December 15, 2022. And that report must include a list of the local governments that are required to comply with the requirements of statute 163.3178 sub 2 sub F, but are not in but if they are not in compliance as reported by the Department of Economic Opportunity. And you also have to have a list of government agencies that have completed the vulnerability assessments, complying with requirements under statute 380.093 sub 3. As far as specifics, I mean, there's more and more specifics, including for special districts, the goals, but they are not really, as far as we could dig into this, specific cost or specific exemptions if they are less than so many square feet. From the standpoint of what this legislation is doing, and I apologize from a standpoint of I'm scanning it at the same time I am responding to you. It has a couple of things with regards to population for the smaller ones, but I am not seeing anything, nor do I remember seeing anything with regards to that particular exemption. It does have a deadline of July 1st of 2023 to complete development of a comprehensive statewide flood vulnerability and sea level rise data set sufficient to conduct a comprehensive statewide flood vulnerability and sea level rise assessment. So I would say that those particular exemptions that you're thinking about are not applicable as far as this bill, or the bill is not addressing these at this time. And of course, like anything else, these are all reports and plans, and it's all going to be subject to rulemaking and some other refinements as we go on, because I think that what they want to know is what's happening, what's out there, how could it impact it, what is going to, what are we going to need, and how much money is it going to cost?
All right. So back to 423.
Okay,
And
423.
Can you please elaborate on the private owner's right to demo a single family residence and replace?
Let me pull up 423. I got to get to the right section. My apologies. Doug, you want to start into that one while I pull the and try to put the thing up on the screen? Or George, whichever one of you wants to take it.
It's with House Bill 423, elaborate on the
That
private-
starts after line 400. Right. I think that's after line 400, which I failed to print, but I can try to look it up.
Let me go back here and I'll put it up on the screen. All right, hold on. Let's see, this is, okay. This is the section on 423 that deals with that. The demolition of a single family residential structure, which is located in a coastal high hazard area. It says local law, ordinance, or regulation may not prohibit or otherwise restrict the ability of a private property owner to obtain a building permit to demolish his or her single family residential structure located in a coastal high hazard area, moderate flood zone, or special flood hazard area, according to a flood insurance rate map issued by the Federal Emergency Management Agency for the purpose of participating in the National Flood Insurance Program, if the lowest finished floor elevation of such structure is at or below the base flood elevation as established by the Florida Building Code, or a higher base flood elevation as may be required by local ordinance, whichever is higher, provided that such permit otherwise complies with all applicable Florida Building Code, Florida Fire Prevention Code, and Life Safety Code requirements or local amendments thereto. Then it goes in an application for demolition permit sought under this subsection may only be reviewed administratively for compliance with the Florida Building Code, the Florida Fire Prevention Code, and the Life Safety Code, or local amendments thereto, and any regulations applicable to a similarly situated parcel. And the applications may not be subject to any additional local land development regulations or public hearings. A local government may not penalize a private property owner for a demolition that is in compliance with the demolition permit. If a single family residential structure is demolished pursuant to a demolition permit, a local government may not impose additional regulatory or building requirements on the new single family residential structure constructed on the site of the demolished structure, which would not otherwise be applicable to a similarly situated vacant parcel. This subsection does not apply to any of the following: a structure designated on the National Register of Historic Places, a privately owned single-family residential structure designated historic by a local, state, or federal governmental agency on or before January 1st, 2022, a privately owned single-family residential structure designated historic after January 1st, 2022 by a local, state, or federal governmental agency with the consent of its owner. So that is what the statute says, and all I can tell you is that you probably will get signed.
All right, while we're still on 423, and then we're going to go to 1140. Tommy, you're on deck. So 423, does the prohibition of on the board placing special conditions on provisional certificate apply to internships only, or does it apply to any provisional application?
Doug, you can back me up on this, but as I understand it, is not specific to private providers. It's just a general prohibition.
I believe that to be correct. I think what we've done is we've actually removed the restriction. And Ron, right where you're at, if you could scroll down just a little bit from where you just were, I think that was the section that actually addressed it, probably about 5 lines below where you were.
Okay.
There we go, right in there. Okay, the duly authorized representative. Now, this is under the private provider section. But as you can see in here in line 265, 264, 265, they have added the provisional certificate as being a duly authorized representative of the private provider, and a duly authorized representative who only holds a provisional certificate under Part 12 of Chapter 468 must be under the direct supervision of a person licensed as a building code administrator under Part 12 of Chapter 468. So a provisional can now be used by a private provider.
Okay. Moving right along, we were going to.
All right, now we're going to go to 1140. So let's see, I've got a couple of them here I'm looking through. So 1140, per Florida statute 553.793 parentheses 5, will small fire alarm projects be considered label permits limited to a $40 fee and allowed to be purchased in bulk?
I believe that's exist. I Googled it real quick of what that, because there's no changes proposed to that section that was mentioned. And I'm going to ask one of the building officials on the line to help clarify that, because I am not familiar with that existing language about labels.
All right, but let me just read the second question to you. If it is an existing alarm system and less than 20 devices are being changed and the volume is over 5,000, do we still need to provide an over-the-counter permit, or can we require a review, or only can we require plans submitted? So 2 parts there.
Okay, on the first part that she's talking about bulk permits, etc., this has nothing with regards to that as any modification or changes. Now, Tommy, you want to handle the second part, the second question?
Yeah, so I would imagine that because this is going to be an over-the-counter type of permit, we will not, fire will not most likely know a price at the given moment. So we would not be able to require it, from what I believe, right at the get-go, but potentially during the called in inspection, if we ask for that, or if we believe that it exceeds that amount, then yes, we would be able to ask for that documentation and potentially deny it at that point.
Okay.
And before you go on, if I can jump in on that one briefly, in some of the new wording in 553.7932, and for those of you that are in it, I'm on line 79 of the actual bill, where they actually identified the simplified permitting process for fire alarms. Under Part B of that, they've defined a fire alarm system project means a fire alarm system alteration. So they're not talking new projects as being able to be under the label program. the alteration for 20 devices or less. Thank you.
All right, a couple more here on 1140. 1140 does not give a time frame. It just says simplified permitting process. So is it to be immediate, within 24 hours? If we are totally electronic, can it stay electronic? Do we have to offer in person? The wording doesn't really give much guidance.
Correct. So what I see on here, it talks about over the counter, and I would defer the time frame of over the counter to some of the building folks on here, as we don't issue over the counter permits in our fire department. Do you have a time frame in yours?
We generally consider over the counter to be either immediate or within 24 hours. If we're trying to do a fast turnaround, which we attempt to do on things like roofs, air conditioning change outs, fences, things of that nature, which aren't really, they don't impact life safety at all. If there's anything that impacts life safety, you may not meet that. But in the bill, it also does specifically say a local enforcement agency must issue a permit for a fire alarm system project in person or electronically. And that's actually line 98. You can see on the screen where that's at.
And then do we know what line where it says over the counter? Does it actually say that?
I didn't see that in here.
No, I did
Okay.
not say over the counter.
All right. I have another 1140
Not
question.
in there.
If a shell permit is applied for and then separate permits are obtained for multiple tenant improvements, each with less than 20 devices, but combined total greater than 20, are they exempt from submitting plans?
Well, once again, I'd have to refer back to that definition. When we did fire alarm project, they defined that as an alteration, not a new system.
Right.
New systems generally have to be looked at in order to be sure that you're in compliance with NFPA 70, NFPA 72, NFPA 101, Florida Fire Prevention Code, perhaps the building code if there's a requirement for the fire alarm in that occupancy. There's a lot of different requirements. And then as Tommy brought up earlier, you've got the battery calculations that you have to take a look at. There's a lot of concerns on a new system, not as much on an alteration. And I have to believe that that's why that definition had gotten put in there as it did.
Yeah, and to add to that, it only talks about, as Doug said, modification of existing. And if you have a situation where you have a shell and you have existing equipment, if each is permitted, I guess this may apply. But if it's permitted as the total of the 60 units or exceeding 20 units, this does not apply.
All right. Are we ready to move on?
Yes.
All right, and then I'm just looking at my watch. It's 4:14. Do we want to answer like maybe 5 more minutes of questions, or like how long do you all?
We can take some more. I think we
Okay.
figured that we last till 4:30 and then we all pass out.
Okay. Does the statute for NOCs require the building department to maintain a copy of the permit record? Does the building department also have liability for the NOC being correct? This seems to be the question a lot of people have when determining who reviews or checks the NOC and how strict the department should be.
George, you want to tackle that one since you've been kind of quiet lately?
Or you may hear some noise around my house. I don't know if you hear that in the background or not, but construction going on. Anyway, so could you repeat part of the question? Was
Sure.
keeping permanent record? We have any record we take in or electronic and are in our files permanently. Statutorily requirements related to that would go under the public records law, which for residential 1 and 2 family dwellings is 10 years. And I would think the same with the sub permits or permits related to a 1 and 2 family dwelling. Does that sort of answer what the question is?
I hope so. If not, they can enter another form
Yeah,
of question.
I think the other part of the question, George, was the record and also verification of the NOC. Can you kind of briefly touched on, is the building department required to verify the NOC?
Well, in our department, we issue the NOC. Unless the applicant, in our cases, the applicant has gotten it from the county directly, but yes, we verify that they duly comply with the lien law, which is the NOC.
Right. So are we required to maintain the NOC with the permit record?
I would say yes, because it's part of the record documents of the permit.
All right. All right. We're gonna go off the update here for a minute. Any movement on inspections of 30-year-old buildings? What happened to that legislation, panel?
It died in committee.
But it's not going to be gone forever, is it?
No, this is my personal opinion. It's not the opinion of this panel or of the legislative committee. This will be dealt with either right after the elections or as part of the 2023 legislative session. And I have a sneaky feeling that based upon all the bills that were introduced in this last session, this is going to be a very long conversation. And because of the property insurance issues we are now having, on which we're having a special legislative session in 2 weeks, the insurance section of our market will be putting pressure to get this dealt with. And I think that there's a lot of questions that have already been raised. I know that privately I have discussed some of them with colleagues of mine and friends, and I have posed a lot of questions that have left some people scratching their heads and saying, yeah, and there's no easy answers. So I think there is going to be a lot of impact changes, not only with regards to the building departments, which are going to have a lot of more paperwork, but it's also going to be on the very basic design of new buildings. One of the questions I asked, and if anybody has any comments on it, please kick in. I asked the very basic question was, you have a building you're designing. How long is it supposed to last? What is the building life on it? Because everything else is based upon building life or equipment expected life. You've seen all those. We have to put in money to replace because end of useful life. What is the end of the useful life of this structure? Is it 40 years? Is it 50 years? Is it 100 years? These all affect all the other subcomponents, so to speak. So I think there's going to be a lot of architects, engineers, developers, building owners, people that want to buy buildings that are going to look at structures a little bit differently, say in another 5 or 10 years, especially if you're buying something that you expect it to last 30 or 40 years, or you're trying to get a 30-year mortgage on it. But as I said, that's my personal opinion, folks. But yes, it will be, it's coming up. There's going to be a lot of conversation. There's going to be a lot of reports that have been filed. The NEST report hopefully will be coming up the first quarter of next year. That will add more impetus to getting something done. And I think the governor will probably do a little push on it once he has more ammunition. That's my opinion again. Anybody else? Shaking heads.
I would agree.
Okay. All right. So I've got several private provider questions I'm going to fire at you all. Is there I think you sort of touched on this earlier, Doug. Is there a difference between private provider CBO versus contract provider? And then what is the enforcement authority on this?
The enforcement authority comes right out of 468. As we read in the definition, the building code administrator or building official, the terms are synonymous, may be an employee of the authority having jurisdiction or may be under contract. If that person is under contract with the authority having jurisdiction, then they are considered to be the building official. And from everything that I have ever heard from the board, they have all of the same rights as the building official as if they were an employee. However, on the private provider side, and that's municipal service. Now, on the private provider side, it's a little bit different. And we've seen many revisions for the private provider. It started out that it had to be an architect or an engineer at the helm of the firm. We now allow for a building code administrator to be at the helm of the firm. And there is also a provision for just a regular licensed inspector to perform private provider inspections on, I believe I don't have that in front of me, so I'm paraphrasing it, but I believe it is on structures that are 1,000 square foot or less, that other people can perform the PPI or private provider inspections. So yes, there is a difference. And I'm sorry, Ann, what was the other part of that question?
Enforcement. I think ultimately, where would you file a complaint?
If you had a complaint and it is on a 468 Part 12 licensee, then you would file it under 468 with through DBPR to the board, the Building Code Administrator and Inspectors Board, and under the disciplinary guidelines, which is 468.621, number 1. I just had it here a minute ago, bear with me. 1I is the section where a disciplinary guideline or disciplinary proceedings can be brought for failing to lawfully execute the duties and responsibilities specified in this part and section 553.73, 553.781, 553.79, and 553.791, which is the specific private provider portion of Florida Statute 553. So in regard to the question that got posted in the questions earlier about a private provider not notifying the municipality in accordance with the statute, if that is what the municipality requires, then that is the section that you would file a complaint under.
Okay, and here we go. Are private providers required to report their revenues to the state, like the requirement for municipalities?
Not that I'm aware of, and maybe
You're
somebody else
private.
knows something else, but the IRS would certainly want to know.
You're-
All right.
You're a
Consider-
private entity, so therefore they're not publicly required to file it other than under the state requirements of the IRS, as Doug said.
All right, and then what is the legislature definition of direct supervision in reference to the private provider internship?
Doug, you want to try that one?
Sure. To the best of my knowledge, there is not a written definition of it. And I will tell you this, that I was at the Construction Industry Licensing Board meeting when they were discussing direct supervision, because there was a probation hearing or not a probation,
Provisionary application, provision license application.
no, it was a disciplinary, they had gotten put on, well, maybe it is probation, where the board is monitoring their activities for a while. And at the hearing where the licensee was supposed to show up, the licensee was not there and his attorney was there. The board asked the attorney specifically, well, where is your client? We want the licensee here to explain this to us. And the answer was the licensee's in jail. He's in prison right now. So the board asked, how can he possibly be supervising his jobs? After a long discussion and several attorneys going back and forth, the board finally came to the conclusion that if the licensee was speaking with his superintendent on the phone at least once a week, that constituted supervision of the construction job. And you never heard anything about supervision being discussed at any of the boards after that meeting.
All right, we've got another question. Thoughts on local AHJs issuing TCOs to private providers or authority to deny the request since it isn't in the statute language?
Okay, you're
Jordan,
talking.
you want to take that one or you want me to hop in on it?
I was going to say,
I'll-
as far as
I
I
would
know.
say-
Yeah, go ahead, George.
a majority of commercial buildings that are constructed, non-residential and multifamily, practically all of them receive a TCO because they're not 100% complete with the project or parts of the project. And we facilitate that process to help them and to allow occupancy or partial occupancy, and while at the same time giving them a deadline for compliance. So it's often happening. It's quite rare with 1 or 2 family dwellings. So could you repeat? Does that answer anything? Or what was the question again?
It says thoughts on local AHJs issuing TCOs to private providers or authority to deny the request since it isn't in the current statute language.
Okay. Well, as I mentioned, we do issue those. We have very, very, very few private providers in our small municipality, but if it did occur, we would issue them because they are a legal part of the Florida Building Code. Florida Building Code is enacted and it gives us the authority to do that. So it'll be up to the local building official, the authority having your jurisdiction.
Right. All right. Well, one other question here. There were a couple of others that I think were answered in some of the other discussion we had. But this one, I don't think this was on our list of what we looked at, but 735, any thoughts on House Bill 735 in regards to county licenses versus state licenses in order to apply for permits?
Okay, this is the local licensing bill that is basically going to eliminate a lot of the local licensing options. I believe that's what 735 is, correct, Doug? If I remember correctly?
Correct.
And that takes effect July 1st, 2023. The question has been raised, and I know that both the Legislative Committee and the Code Development Committee, to a certain extent, has kind of voiced their thoughts. And it's a quandary because it does affect the consumer. And if the objective is to keep the consumer safe, but at the same time makes things simpler, there is no mechanism locally once you eliminate those local licensing requirements, such as for window and door installers to provide the proper hurricane impact installation on a product. And remember that the product is only as good as when it's properly installed. Storefront, which would be commercial storefront, would be no local licensing anymore. It's not on a state licensing level. DPPR does not have that category. So there would be a risk with regards to not only liability, but also workman's compensation. We have not really taken a stand per se, but the general consensus, or at least the feelings, is either the state decides under DBPR to create those categories and manage them on a state level, or guys, this is not a good idea. And Doug?
Sorry, if I can just interject in that, Ron, something that you had mentioned. One of the things that's very important to keep straight is that licensing has nothing to do with permitting, and permitting has nothing to do with licensing, except for the fact, how do we give a permit for work to an unlicensed contractor? In theory, we can't do that. It doesn't mean that the work doesn't have to be permitted. The work is still required to be permitted under the building code, unless the building official deems it to be a repair that doesn't require a permit. So this is a big part of the discussion that I've been having in a lot of different areas, is how do you go ahead and issue a permit to an unlicensed contractor now?
Mm-hmm.
That, I think, is the bigger issue. Plus, we're going back to 2004, 2005, when the construction industry got in all kinds of trouble with the state on the workers' compensation because everybody was a 1099 employee. we're going to have to be issuing a permit to a Division I contractor who's going to be hiring 1099 unlicensed contractors again. So I don't know how that's all going to play out. I've had a lot of conversations with it, been in a lot of meetings, and I don't think that everybody has the answer to it yet.
I agree with you. It's kind of they've opened the Pandora's box, so to speak. And I know that in certain jurisdictions, they have a prohibition against general contractors with a category 1, category 2 to pull specific sub permits. They do not allow them to. So again, you're running into, well, if the local ordinance says you can't pull this type of permit, then who does pull the permit, and who is the proper person, and who is the person that is insured? And as you said, you raised the one issue which several of the people have raised to me, is he says, you're going to get a bunch of people that are going to come down in their little pickup trucks who haven't got the foggiest on how to install this stuff, go and install it. It's going to fail. And then you're going to have a general lawsuit because some people are going to point to, and who installed this? Well, the manufacturer is going to wipe his hands clean and say, we're not liable, because part of our thing is it has to be properly installed by a qualified installer. And in fact, we have one firm that I deal with specifically says licensed commercial glazing contractor. If there is no licenses, who are they going to sell to? Their warranty automatically is void, even if the product is installed, according to the wording of how their warranty is currently worded. Anyway, George, Tommy, well, Tommy, you don't get too much. Well, you do. It'd be licensed installers of alarm systems. George?
Well, one thing that could happen, this whole issue of removing local licensing could totally backfire, because you can require that a qualified contractor pull the permit for installing windows or many of this, things that are going to be done away with through this statutory proposal. And of course, that would be the opposite of what the intent is of the folks that put that bill forward. But I mean, you can certainly do that. You say it requires a qualified license holder.
Ron, Tim McGrath of Florida's DBPR will be at our annual conference in Orlando in a month. At our general session, 8 o'clock that Monday morning, he is going to talk to us about unlicensed activity, and specifically, that House Bill 735. So people can get more information on that if they come to conference. But I wanted to ask you, Ron, is there anything you want to hit before we wrap it up?
My thanks to all that have worked so hard to put this together, to Doug, to George, to Tommy, to Celeste, and lastly to Ann, and of course Kathleen, who is not here on the screen, but who has been in the background worrying, like, is everything together? Is everything going on? Is everything okay? Do you need anything else? So Kathleen, thank you for those warm thoughts. And there's been a lot of work, not only by these people here that I mentioned, by the committees. I know that Tommy has on their organization, there's a lot of people that have worked very hard on some of this legislation and sweated through the little minor changes and hiccups at the last minute. So my thanks to all that have attended. And all I can say is, if you're interested in any more of this, this is being recorded. It will be available at no cost, so everybody can see it again, those people that were not able to make it. And if you have any specific questions, please feel free to drop us a note. We may not have the answers, but we'll try to help you whatever way we can, whether it's under fire, if it's under building, if it's under just general questions on it, and use BOAF as a resource. And that's it, Ann. So I leave it to you.
Thank you. And Ron, when the session ends, a survey is going to pop up. If the attendees could please complete that so they can tell us what they're interested in, because we want to continue bringing them the content that they want to learn more about. And just a reminder, the information in this webinar is not a substitute for reviewing the legislative changes with your city or county attorney. And we are hoping to have this up available to download this coming week. And thank you, everyone, we appreciate everyone for being here. Thank you. Have a great evening.
Thank you, and have a nice, safe day, and make sure that have a safe commute home if you're not home yet.
Thanks, Ron.
Bye-bye.
Bye-bye.